Hi, I'd like to thank everyone for being on the call this evening. Tonight we're going to hear from our Utah Attorney General, Mark Shurtleff, and his Chief Deputy Attorney General, John Swallow, about the Obamacare and the Supreme Court hearings that we've been hearing and watching attentively over the last couple days. They've both been in attendance, and I'd like to turn the time over to them so that they can introduce themselves and tell you a little about what's been going on in Washington, D.C. and in the Supreme Court and about the case. If any of you listening have a question, please press *3 and we'll try to get to your question tonight. Also, the audio of this recording will be available late tomorrow on our website at www.johnswallow.com. That's John, John, Swallow, SWALLOW.com. And I'd like to turn the time over to our Attorney General, Mark Shurtleff. Mark, how's things going in Washington, D.C.?
Yeah, they're great, Dan, and thank you, everybody, for joining. My Chief Deputy, John Swallow, and I have just had an incredible 2 days. It has been, extraordinary for us to be front and center, right in the well of the Supreme Court. Almost can reach out and touch the justices. In probably many Supreme Court authors and experts have said one of the most important trials in history, let alone of the century, and it really ranks up there for a number of reasons that John will explain to you in just a minute. We've been participating. I want you all to know that one of the first things that John did when he came on board over 2 years ago now was I assigned him to take the lead for the state of Utah on this challenge to Obamacare, or what's called the Affordable Care Act. And I want to do that because I knew John had not only litigation experience, but also leadership ability to work with the AGs and their chiefs across this country in challenging this unheard of expansion or attempt to expand federal power. And John's done an extraordinary job. And so that participation preceded. Let me just give you a quick background, and then I'll turn to John, and he'll explain to you what's been going on the last couple of days and how the arguments have gone. It was several years ago now when we knew that Congress was, and President Obama was going to push national health care. And so a number of, actually just a handful of AGs decided to monitor what they were doing and to let Congress know when we felt like they were going beyond the bounds of the Constitution. Many of you may recall that we, early on, there was what was called the Cornhusker kickback, or the Nebraska Compromise, which favored Nebraska but in an unconstitutional matter to the exclusion of other states. We wrote a letter to leadership in both the House and Senate and told them they couldn't do it. They decided not to, as they then went forward talking about individual mandate and some of the other things that we felt were unconstitutional. We let them know that. Unfortunately, they stopped listening to us. And so as we, in the closing days and even the very last night when the vote was being taken, a number of us were on the phone talking to each other, Republican attorneys general, framing up our last final arguments and planning to be able to bring our lawsuit within hours of President Obama signing the Affordable Care Act into law. And that's exactly what we did. Since then, we've been joined by a total now of 25 other states, so there's 26 states total in this lawsuit. It is as the Supreme Court has recognized, one of the most significant cases that they've heard. They demonstrate that by the fact that they set it for arguments over 3 days, 5.5 hours of total arguments. They have changed their procedure for getting the word out, and instead of waiting until the end of the week to release transcripts and recordings, they do it almost immediately afterwards, knowing how important this is to the public at large. And so a very significant event. And with that, John, who has been on top of this and leading this from the very beginning, can go to explain to you the main issues and what we've perceived so far of the justices. John?
Thanks,
guys,
Mark.
I want to jump in. John, I apologize. I need to remind everybody, if you do have a question for Attorney General Shurtleff and Chief Deputy John Swallow, please press *3, and we will get you into the queue and try to ask your question tonight. Again, that's *3 to ask your question.
Thanks, Dan. And, Mark, thank you. There is a lot to talk about, and we appreciate those of you who've called in and are joining us in this conference call. this brief report of what's been going on here, but just a little more background about what this case is about. And I think that as you understand, and I'm sure many of you who called in are understanding it more and more with all the news media that's giving us coverage here, and also what you've studied as well. You wouldn't be on the phone call unless you were really concerned about what's happening with this law. But at the end of the day, what really shocked us as states was the arrogance of the federal government in believing that they could exercise unlawfully power under the Commerce Clause and force individuals to make a purchasing decision for the first time in our history. And as the arguments went forward the last couple of days, it became very clear that that was certainly the position of the states and most of the justices, as case law was explained, that never before has Congress tried to exercise this power, although the Commerce Clause has certainly been with us since the formation of our nation. And that should shock a lot of people, and certainly it was shocking to us more than 2 years ago as we got involved in the case. The issue truly is, how do we safeguard the concept of dual sovereignty and limited government in our country? And I'll just give you an example from my own house, and maybe my wife may be on the phone, so I'll have to be a little careful here. But I tell the story that in our house we have the concept of dual sovereignty as well. I have been awarded the garage and the shed and maybe a few little nooks and crannies in the house, and I'm sovereign in those areas. And my wife certainly is sovereign in the other areas of the house. And I feel like that's a great representation of how it should be in government. The federal government was created with enumerated powers, and they were given the supremacy clause to make them supreme in those limited areas. And commerce was one of those areas, the regulation of commerce among the states. What we've got now is the federal government trying to park cars in the kitchen, in the master bedroom, and in the living room. And what we need to do with this law is put them back in the garage where they belong, so they don't have general power over the whole house, but limited power in their area. And what they've tried to do by allowing or forcing Americans to buy a product is, with the unlimited power that would be in terms of, if you have one product that they can force you to buy, what limitation is there from them forcing you into many other decisions and becoming the general government over our lives? And the federal government was not set up to become the general government over our lives. It was set up to protect our liberties. The general governing was left to the states and the people who can closely manage the states close to home. And federalism, or states' rights, another word for that, is about truly protecting the rights of individual liberties. And so that is what has been front and center on the fight of the states from the very beginning of this lawsuit. That is the charge that the Founding Fathers gave to the states as they were to protect federalism. So that's what the case is about. Really try to be as brief now as possible. The first day of hearings was about whether or not this penalty, which is assessed to everyone who does not buy insurance, starting in the year 2014, this penalty of around $2,200 per person, is a way of raising revenue through a tax, or whether it's actually just a penalty to encourage enforcement or the purchasing decision by people to encourage them to purchase the insurance. Yesterday's arguments were all about that issue, and the reason that's important is because there is a law called the Anti-Injunction Act, which was passed in the 1860s, which was designed to protect the ability of the federal government to raise revenues through taxes. The idea is that under that law, you cannot sue the federal government on a tax unless you're seeking a refund of taxes you've already been paid. And the reason that was important was the Congress wanted to protect the revenue source of government from a lot of lawsuits that would prevent the government from operating with enough capital or cash in its coffers. The reason it's important in this case is because the mandate does not go into effect until 2014, and therefore no one has been assessed a penalty at this point. And the argument would be, if it's a tax, the lawsuit was premature and it's jurisdictional, which means that if it is a tax, we could not go into court and actually sue about the mandate until 2014. That was yesterday's arguments, and it was a phenomenal experience as it became very clear to us very quickly during the hearing that the justices were not buying the fact that the President and Congress basically said throughout the bill that it was a penalty, that it was authorized not under the General Welfare Clause, which is the taxing clause, but under the Commerce Clause, which the penalty would come under, that the government could not come out now and say, oh, we really meant it was a tax. And that's jurisdictional for us. It's very important for us, and I was frankly a little bit nervous about it as we were going in, wondering how the justices would view, that argument. But it seemed pretty clear as we went through the hearing that the justices were not buying the argument that it was a tax because it was not assessed in the tax code. It was simply, in the words of the justices, it looked like it was not a revenue and raising measure. It was more of an enforcement promoting measure. And that was yesterday, and I thought that went really well yesterday. I'm going to go ahead and give another comment about today, and then Mark, you can jump in if you'd like to. Today was about the mandate, and that was squarely front and center. Each side had an hour to argue it, and it became very clear very quickly as the government went first that the conservatives on the bench were jumping in and asking their hard questions. But what was really interesting to us was that Justice Kennedy, who was perceived by many to be the swing vote, had voiced some real concerns about the mandate. He asked a couple of questions. One question was, he said, can we really create in this country commerce? Can Congress create commerce so we can then regulate commerce? And he asked a series of questions along that line, really casting doubt on the fact that that was a legitimate exercise of congressional power to actually create commerce by forcing someone to make a buying decision. The other question he asked was, are we prepared in this country right now through this legislation to really change the relationship between the federal government and the people by forcing them to actually buy something for the first time in our history? Those two questions gave us a clue that Kennedy may be on our side on this issue, which is very significant because we have 4 people that we are pretty certain will be voting for the bill, and 4 people that we hope pretty certainly are going to vote against the bill, and then Justice Kennedy in the middle. I thought today was a phenomenal day. I felt like the federal government's arguments weren't very tight. They couldn't answer the question of how this power would be limited if it was a lawful exercise of congressional authority. In other words, if you can force people to buy insurance, is there anything you can stop Congress from requiring us to buy down the road? That they didn't have a good response to that question. They haven't had a good response to that question in the lower courts as well. They haven't had a good response to that question in the briefing, and they didn't have it today. So we felt very good about how today went. We felt really excited about how well the state's attorneys performed in court. We have Paul Clement, who's the former Solicitor General under George W. Bush, who was the voice for the states, and he did a masterful job on his feet and was well prepared and was up to speed on all of the cases and was able to go right back to the justices who were asking him hard questions. And we felt at the end of the day, like Senator Mike Lee, who was there with us, said, the states sure got their money's worth today. So it was a great day. We're very optimistic. We know that these justices truly don't necessarily give a whole lot of clues as to how they're ultimately going to vote. We know it's a hard case, but where we started as being ridiculed by most of the law professors out there, most of the talking heads out there saying that states had no business even being in a lawsuit, to where today, after 2 victories, we are not only in the game, but it looks like we have a very good chance to win this case, which is fundamental and monumental in terms of our individual rights and liberties and the balance of power between the federal government and the rights of the states and the people. So this is a case that is a case for all times, and it's just an honor to be involved in it. And Mark, I don't know if you have anything to add as we go into questions, but I thought I'd just give that kind of quick overview or lengthy overview of kind of where we are, why we are, and where we're going tomorrow. And tomorrow really is about 2 things. One is about the severability part of the act. In other words, if one part is unconstitutional, does the rest of the act stand or fall? Can you carve it out? And then also another severe infringement on states' rights under the 10th Amendment, and that is the Medicaid expansion, which we'll argue as well tomorrow. So we have 2 arguments tomorrow. Mark, anything else to add?
I want to get to questions, but let me just say this: it's not, you would think that because we're on one side, we're gonna read this the way we want to read it as far as how it might be going. But very quickly, I spoke with Jeffrey Toobin, just on the way out of the courtroom, he's one of the most renowned Supreme Court scholars in the country, originally very kind of critical of our bringing our case back in the day. He's also written a number of books about the Supreme Court. He came out today and reported that he believed that it would go 5-4 in favor of the states and in striking down Obamacare. And then tonight at dinner, I ran into the Supreme Court reporter for the National Law Journal. This guy, again, that's all he does for the National Law Journal as a lawyer is to analyze these cases. He also felt like, he said, I'm not going to predict, but he said he felt like it did not go well for the federal government today. With that, happy to answer questions.
Thank you, Mark and John. First, I want to remind our callers that if you press *3, you'll be able to get into the queue to ask Utah's Attorney General, Mark Shurtleff, and his Chief Deputy Attorney General, John Swallow, who are fresh out of the Supreme Court listening to the case being tried for the Affordable Care Act. Again, *3 if you'd like to ask a question. Also, we have a poll question that we will be getting to later after our first call, but we'll be doing some interesting things this evening. First, I'd like to take a question from Matthew from Pleasant Grove. Matthew has a question in regards to the Obamacare case as well as in regards to Utah law. Matthew, go ahead and ask your question.
Yes, thank you for having me this evening. And I just wanted to ask if the legislation that Utah legislature passed previous to Obamacare is in any of the arguments and as part of the presentation of the state side, so that does it need to be addressed that Utah had a law previous to Obamacare, and does that have any bearing on the case and the arguments that go forth? And then a side comment, I guess, from what you just said about Kennedy's statement of being ready to create the mandate, make sure that the government side doesn't give Justice Kennedy any reason to believe that we are ready, so to speak, to receive that type of mandate.
Okay, well, thank you. First question first. This is John. The standing issue was something that we were really concerned about as we first filed the case, because when we first filed, we didn't have any parties besides the states. We didn't have any individuals, and we didn't have the National Federation of Independent Businesses. After we filed our case with 13 states, we went to work and we recruited more states. We originally had 4 states in the discussions, and Utah was one of those 4 states. We had South Carolina, we had Florida, Nebraska, and Utah, and we were kind of doing the research together and kind of putting together a strategy. One of those strategies was to bring a lot of states together to have a united front, which is a strategy I think can work equally well on public lands as we're getting ready to get into the public lands fights in the state as well. Another strategy was to work on some legislation with our legislatures. Unfortunately for us, at this time, Utah was just gearing up and getting into its legislative session, which actually ends in March, but during January and February, when things were really moving forward and looking like something was going to pass and be signed, we went to our legislature with some language that made it illegal in Utah to actually have the federal government require Utahns to buy health insurance. What was amazing and heartwarming was when Judge Roger Vinson in the Florida case issued his ruling a year later, he shouted out to Utah and Idaho as the reasons for we passed our legislation. I think it was signed the day before the law was signed by President Obama. So it became official law the day before, and because it became law before, the judge ruled in his ruling that Utah and Idaho and the other states all had standing to bring our lawsuit. And what's very significant about that is, and Matthew, I appreciate the question, is that if the states don't have standing, then they don't have the right to bring the lawsuit. What's also impressive is that all around the country, cases were being filed, and everyone was being kicked out on a standing ground or some other technical ground, but our case was not being thrown out. And the only reason we are in the Supreme Court today, frankly, I believe, Mark, and you can disagree with me if you want to, is because we actually won at the lower court level and we won at the Court of Appeals. When we won at the Court of Appeals in the 11th Circuit, we caused what was called a division in the circuits. When there's a division in the circuits on a national law, the law becomes dysfunctional in a sense because some of the country doesn't have to follow it. So this became very important to our ability to go to the Supreme Court. When the Supreme Court saw there was a division, they had really little choice but to take our case up. and grant certiorari, which they don't have to do, but they did it in this case because of the one lone victory of the states. At this point in time, I'm sensing if we get past the Anti-Injunction Act, the standing is not an issue that will be addressed by the council or by the court, and that is because when we amended our complaint in the summer after we filed in March, we added some parties. We added 2 individuals who were being harmed by the mandate, would be harmed by the mandate, and we also added a lot of businesses across the country through their association, the National Federation of Independent Businesses, and there was no way that the other side, the government, could really argue effectively that this case was not proper with standing in front of it upon the addition of those parties. And so standing really has become less of an issue moving forward because of I think partly because of the law we passed and what the judge said in the district court, but also because we added additional parties. Mark, do you have anything to add to that?
No, I don't, other than that just on the fact that what the 11th Circuit did was brought out today. We've been asked by several people whether this was partisan or still is partisan. That was the original criticism, was that Republicans lost in Congress, so therefore Republican attorneys general are going to file this frivolous lawsuit, and you should, all the experts that John mentioned that called it frivolous out of the get-go. Obviously it's not frivolous. The Supreme Court takes it very seriously, and we've been winning every step of the way. But what was interesting, and it's not a partisan, the judges aren't being partisan necessarily. We had a bipartisan split in the 11th Circuit. We were nervous about the 11th because there were 2 Democrat-appointed, Clinton-appointed judges and 1 Republican, and yet we had one of the Democrats side with the Republican because they interpreted the law correctly. And we know that they aren't Republican or Democratic members of the Supreme Court, but certainly we know the liberal political philosophy of some and the more moderate or conservative philosophy of others. So Kennedy is the key. Matthew, you hit it right on the head. He is our concern. He's the one we've been arguing to. We were pleased that he jumped off with the 4 minutes, into the federal government's argument and immediately asked the very question that we were asking. But then he ended up 5 minutes before it ended with a question that sounded like he was considering the federal government's position. So he's keeping it. He does that, I think, so that people continue to question him, and he'll have that kind of ability to go both ways. But I think the majority of his questions lead us to believe that he is going our way.
Right. Now, Mark, to finish the second part of his question, we'll be very quick on this part. He asked if Justice Kennedy seemed like he was ready to make that significant step and change the relationship between the federal government and the individuals. One thing that was very apparent from the hearings today is that the court is drilled in on the fact that there are 40 million people in this country that don't have access to insurance, according to the government, and that's a great concern to the court. So, there is a lot of energy on the part of the court, I think, and willingness to really give a lot of leeway to the federal government on how they wanted to solve that problem. We're hopeful, though, based on the comments, that they'll do it in a legal way, a constitutional way, and force Congress to come back and do it a different way that they have the power to do under the Constitution, rather than to force people into the marketplace under the Commerce Clause, which we've very well asserted that they don't have the power to do. Let's move on to the next question.
Thank you, John and Mark. First, I'd like to go to our poll question for the evening. The question is, how do you think the United States Supreme Court should rule on the Obamacare lawsuit? Press 1 if you think they should strike down the law in its entirety. Press 2 if you think they should strike down just the part of the law, such as the individual mandate. Press 3 if you think they should uphold the entire law. And press 4 if you're undecided or don't know. Again, if you'd like to ask a question tonight, please press *3 to enter into the queue, and then also this will also be on its entirety in the recording on johnswallow.com. We have a question from Ron from Layton. He has a question about when the case will be decided. Ron, go ahead and ask your question.
Thank you for taking my question, and also thank you for this historic conference call tonight and all you're doing back there. I'm wondering, they said today that this would probably be decided in June. Do you think from the arguments you've heard that it might be before then? And then secondly, what if this is struck down, which we anticipate and pray that it will be, do you anticipate that this would have a positive impact for Republicans in the upcoming November election for president?
Well, the way these work, the terms go from August until June each year. And so the Supreme Court picks the number of cases that they want to hear, and the case they're going to hear arguments on, and then they make decisions, and their decisions are normally all done by the end of the term, which is the end of June. They typically save the hardest cases and the most important cases for the very end, and so that's why we think that it will probably be decided in June. Besides that, we only have a couple of months, and this is a very complicated case with, as Mark said, 5.5 hours of hearing, and so we expect that they'll probably take as much time as they need, and probably until the middle to the end of June to answer. Second question is what impact? I'm trying to remember. I wrote down what impact. What impact will Mark, did you get
will it have on the election if we can
the elections in the fall? You know, it's hard to say. Some people argue that it will have, if it's stricken down, it will actually help remove something that would be a campaign point for Mitt Romney against Obama, because Mitt Romney has said, assuming he's the nominee, I think he will be, Mitt Romney said that the first thing he'll do as president, he'll try to repeal the law, notwithstanding what he did in Massachusetts. And of course, President Obama is going to fight tooth and nail for the law. So some people say it'll be a helpful thing to President Obama because it'll take an issue off the table. Other people will say it proves that the American people are right, that this is a very poorly written, unconstitutional mandate that the Americans resent, and that if it's upheld, it will be hard on President Obama for that reason. So, Mark, do you have anything to add to that?
Just this, that if, I'm sure that if it goes down, President Obama will become, we all know, very political about it. He will blame Republicans for the fact that seniors and young children and the poor won't have insurance, and he'll try to turn that into, work it his way, as we all know he'll do it. So it'll still give, Mitt Romney, and it'll really take him and the leadership, Republican leadership in the House and Senate, to come back and say, we still are ready to do what we need to do. And it doesn't matter how good or what you want to accomplish. In this nation, it's a rule of law nation. We have to do things by the rule of law and attack back as to the fact that the justices of the Supreme Court have ruled that you, in your haste to do, to cram something down the people's throat, violated the Constitution. And do we really want a president to do that? So I'm sure both sides will stack this and be able to work it. I mean, the key is obviously we'd like to. There's no guarantee, even if we take the presidency, that we'll be able to get enough votes to be able to repeal Obamacare right away. So obviously we want it done. We want it down. We want it gone by the 1st of June.
Right.
Thank you, Mark and John. We have another question from Sharon in West Valley. Sharon has a question in regards to the bill and why wasn't this legislation voted on. Sharon, go ahead.
Thank you for the call. I really appreciate you guys taking the time to let us have a voice, because I've been upset about this for quite a while. And I just feel like, as an individual, why are we not given the opportunity to tell what we want? It is dictated, and I just, as a free citizen, don't feel like we should have those kind of things thrown and enforced on us and said, you have to do it. So I just appreciate the call and ask.
Great. Well, we feel the same way. We feel like this is a free country, that those who fought and gave their lives for America in the Revolutionary War, those who were on the ground floor of the Constitutional Convention, they understood what an oppressive, strong central government could do to rights and freedoms and liberties, and that we feel the same way as Americans today. That's how I feel deeply in my heart. I call it the freedom gene that we as Americans possess. So we won't be told what to do. We won't be pushed and shoved around. We were really just appalled, like Mark said in his introduction, about how the process went in Congress, where they had the Cornhusker kickback, like he talked about, and this whole process of even how this bill was passed was just just like I said, arrogant, and it was abhorrent to those of us. In fact, one of the first things we researched was what kind of a case we would have if we sued on the process of how the bill was even passed, because they passed it through a reconciliation process rather than having the whole bill passed by both the House and the Senate in its complete form. And so we were just shocked and alarmed about that whole process, and it really felt like a manipulation of what was right, and a worthy process that you usually go through in Congress, if you can call it that, but a manipulation. It just didn't feel right, it didn't smell right, and it made us very angry as states' attorneys fighting for federalism. And so we ended up deciding that we could really attack it on constitutional grounds, and that's the strategy we took, and it turns out like it was the better strategy of the two strategies. But it was a shocking experience to be in the Attorney General's office and watch this unfold before our eyes, and really see when Scott Brown was elected that it didn't matter because they weren't going to vote on it again anyway, and that this president was going to ram this unlawful, unconstitutional bill down our throats and create a quote-unquote legacy of, I think, unconstitutionality and arrogance. And I think that's the legacy this president is going to leave on America when he's defeated in November is a legacy of arrogance and disregard, blatant disregard for our rights and liberties as the American people.
Sharon, let me just jump in. And first of all, thank you for your comments and for saying how you appreciate us being open to you. And let me just give you a little insight, if I can, off the subject matter about John Swallow and why he's going to be a great Attorney General, just really an extraordinary public servant. Public service is about contacting the people and being with the people. Today, after the cameras and the meetings we had with other AGs, and by the way, John, as a chief deputy, is already well received, well respected by my colleagues, the other attorneys general. In fact, John, if you look on some of the videos we have available, stood up in the front and shoulder to shoulder with the other attorney general in this case and spoke to the media today. But more importantly, after a lot was done and cameras were turned off, John says, let's walk out to the front of the Supreme Court. Most of the crowds had gone because the cameras had also disappeared. But there were still people there from all over the country who felt very, very deeply about this. They traveled out here to have their voices known. They're very concerned, just like you are, Sharon. And John just wanted to go out there and just talk to people and to share in this moment and answer the questions and to see how pleased these American citizens were that even though we're not representing them directly in the lawsuit, we are. And we spent, about an hour, John, out there. That's the kind of man you're going to have as with John Swallow as an Attorney General.
It was a sweet experience, Mark. Thanks for sharing that. Mark was the same. It was a sweet experience to have people slap you on the back, give you a high five, and say, "We love you, thank you, we're praying for you," and to feel the love of liberty and freedom in the eyes and in the voices of the people who came here was one of the experiences I will take away from here and never forget. Thank you, Mark.
Thank you, Mark and John, and thank you, Sharon. We have a special treat. We've got Riley, who is in high school and has a question about paying for this. So, Riley, go ahead and ask your question for Attorney General Mark Shurtleff and Chief Deputy Attorney General John Swallow.
Okay,
Riley,
one second.
Are you still with us?
Yeah, I am. Just one second. Let me get to my page. Okay, so my current issue is that I'm 18. I don't have a job. I really have no other choice on what to do because I have no way to pay for anything. What's the age restriction on this law?
Well,
John, you want to go or do you want me to take it?
Go ahead.
Yeah, Riley, appreciate that. That's it's interesting that many of the justices talked about you, Riley. Now they didn't mention your name, okay, but the really question was people in your exact circumstance. And John, maybe you remember which one it was near the end. Scalia or somebody said, "What about that young man in America who is healthy, who's just starting out, who's having to make financial decisions, who doesn't believe they can afford insurance because they have to pay tuition or rent or some of the other things that our young people are faced with." And the federal government is taking, Riley, away your choice in that and saying, we're going to decide for you, and you're going to have insurance whether you want it or not, and if you don't pay it, we're coming after you with a big, nasty fine. And so really, much of the debate today and much of this law and our argument against it really surrounds you and whether you can be forced to participate in the commerce of health insurance. And our argument, of course, is that you cannot be forced to do that.
Thanks, Mark. I think it may have been Justice Breyer actually earlier on when he was saying things. But that's exactly the point they made. It was these kids, when these kids, 18 to 26 now is a kid for me because I'm nearly 50 years old. But these healthy young adults don't need insurance, but they do need to buy a car. They need to pay for their college tuition, and we're really taking away a decision from them by forcing them to pay for health insurance, a decision that they might take to buy a nicer car or a motorcycle or invest in their education because we're forcing them. And that's part of the problem with the bill. It forces people to buy something they don't need. And everyone agrees that someone who's 21 or 22 probably doesn't need insurance, but we're going to force them to buy it even though they don't need it so that those who need it are able to buy it as well. And so that's kind of the trade-off they're talking about, but it truly hits you at home. And that is what is important about this, Ryan.
Well, Riley, thank you for being involved, and thank you for your question. We have our next question for our audience. We want to give our audience a chance to voice their opinions, and after listening to this call and the questions and the answers to the questions that have been asked, can John Swallow count on your support in the race for Utah's Attorney General to continue this fight against federal infringements on our rights? So press 1 if John can count on your support. Press 2 if you're supporting someone else. Press 3 if you're still undecided or don't know. And we will take our next question. We will take Linda from Linden. Linda has a question about Justice Kagan and whether she should recuse herself. Linda, go ahead. Ask your question.
First of all, thank you both so much for the good job you're doing. You're making us proud. But I don't understand why Elena Kagan is allowed to be on this panel. She, as I understand it, carried the water for President Obama with this whole law, and it seems to me like a conflict of interest. And why can't we do something about that?
Well, thank you, Linda, for that great question. This is John, and Mark, you can jump in if you like. But this is something that's concerning to a lot of people. I mean, when you have what you feel like is a conflict of interest, and then you're sitting on an important case, a landmark case, a once-in-a-lifetime case like this, as a former member of the executive team, you have a real conflict. And the problem is that these justices actually really police themselves. There's a separation of powers issue, and they make the decision about whether or not they are too compromised to be involved in a case such as this. And let me tell you, that leads me to another point that I think is really important. As I left the courtroom today, and I had a chance to sit on the front row and actually pass a note to Paul Clement, who was actually the voice for the states. It just was so clear to me, as you look at who's on the bench, that who we elect as president has such a lingering impact on our nation and the decisions of this separate branch of government that it is absolutely crucial that we elect a Republican in November. And frankly, Mitt Romney has got to be that person. He's the only person, I believe, who has a chance to beat President Obama in a general election in November. But as I looked and listened to Justice Roberts and Justice Alito for the last 2 days, and how they really framed the issues and how they really felt, and then as I looked at Justice Kagan and Sotomayor, the legacy of President Obama, there just could not be a more marked contrast between the two sides. And so you count on these justices to have the integrity when they're super involved in a case or where they have a conflict to recuse themselves, and that's a kind of a personal check and balance on it. But at the end of the day, we also have to realize that they can make that decision, and that who we elect as a president, probably the single most important thing that they do is that decision on who they will appoint as a justice. Mark, do you have anything to add to that?
No, you're absolutely right. They do have that. But Linda, you're absolutely right. It's very clear where she stands. In fact, Justices Sotomayor and Kagan were, by our tally, asked more questions than anybody else, which is extremely rare for two very junior justices to do when there's only so much time and all the justices are wanting to ask questions. There seems to be a certain arrogance there as well, and they made it very, very clear. In fact, it was interesting to see kind of their inexperience, or maybe they're just going to try and change the way things are done up there. And I'm sure that the Chief Justice and the senior justices were not at all pleased. And that'll factor into their discussions, not only in this case but others. And that is that while the government's attorney, federal government's attorney, the Solicitor General Varelli, was arguing, and of course that's where you have the Chief Justice and Scalia and others picking apart his argument, that if they felt like he was getting in trouble, they would actually rescue him. They'd jump in and ask a very easy softball, kind of lead him back to the question, and so he'd start answering their question as opposed to finishing his question to the senior justices. I noticed very clearly, first of all, that you just aren't really supposed to do that, but as it turned around, and as our attorneys were arguing, and Sotomayor and Breyer and Kagan were all attacking them and really trying to rip them apart, you did not have the Chief Justice or the senior judges jumping in and tossing them softballs. They let the others ask their questions. So I see this kind of dynamic developing. It causes me concern knowing that those two justices will be on the court for a very long time to come.
Well, thank you, Mark and John. I want to, first of all, continue to thank everybody for being on this call and discussing the Obamacare court case that's going on in the Supreme Court, and for our Attorney General, Mark Shurtleff, and our Chief Deputy Attorney General, John Swallow, to continue to answer your questions. We've got one more from Paul from Midley. Paul has a question about cash for clunkers and how this is any different from that. And so, Paul, go ahead and ask your question.
Thank you. I'm very critical about how the government mandates what to buy and not to buy. And so I was wondering what's the difference between mandating insurance and these other programs that was phasing out incandescent bulbs and high-definition TV and the car junker programs, how those are different.
Great. This is Paul.
Yes.
Paul, thanks for the question. It's interesting you'd ask that question. I don't know if you've listened to the tapes of today's hearings, but that very issue was addressed extensively today, where justices really drilled down on the fact that, there is authority for Congress to, for example, have the EPA put serious restrictions on emissions standards for new automobiles that they sell, and all kinds of things are regulated. Then why can't they regulate the insurance industry by forcing people to buy a product they don't want to buy, health insurance? And it became very clear as we argued those points that it's one thing once someone makes a decision, for example, to sell an automobile for cash a clunker or something, or a decision to buy an automobile that has a pretty tight emissions requirement from EPA. Once they make a decision to get in the marketplace, that can be very highly regulated. But what has not been ever done before is to force someone to buy that product. And the great example that, and I think it was Alito or Roberts. I'm not sure which one made this example. But going back to the maybe it was actually probably Scalia, going back to the early days of the country when they had carriages, and there was a tax per se given or charged to someone who drove a carriage, and everybody who had a carriage had to pay a special assessment or a tax, that was a valid exercise of authority because of a Commerce Clause issue. But the point that was made by the justice was you don't or excuse me, it was actually the argument made by our attorney, Paul Clement. And he said, but you can never imagine the Founding Fathers would have sanctioned a tax or a penalty on someone not buying a carriage. If you don't buy a carriage, we're going to charge you money. That is unconscionable to think the Founding Fathers would have ever agreed to that kind of thing. The other point he made was, we had a Commerce Clause, but it didn't mean that we were going to force foreign nations to engage in commerce with the United States. Well, that's exactly what we're doing with this bill. We are forcing people to get engaged in commerce, to buy a product. So what you're saying, Paul, it makes a lot of sense, but once someone makes a decision to get into the stream of commerce, it can be regulated. We know that from precedent, and we know that from the Commerce Clause. But the distinction between those types of programs and what we have here today is very clear. The difference is they are forcing us to get into the stream of commerce to buy a product, not regulating us once we've already made that buying decision.
Let me just bring this up, because you all might find this interesting, and John, your discussion reminded me of this with Paul Clement talking about carriages and the Founding Fathers. None of the other people who argued, and clearly not the government's attorney, the federal government's attorney, talked about original intent. And I was just so impressed, weren't you, John, with Paul Clement, who kept going back to the Founding Fathers and at ease with facility to quote from them and what they intended and what they did not intend, and to apply the understanding of what the role of Congress is vis-a-vis the states in referring to original intent of that great founding document. I know most people on this phone probably believe that as well. We know that many of our Democrat liberal opponents do not. They feel differently. But it was great to see that discussion, and I'm sure there are many of those on the court, even some of the more liberals who still understand how important it is to go back to what was originally intended by the Founding Fathers and to be actually educated in that regard by our great counsel.
Mark, you're right. And in fact, just to let everybody on the phone know, we actually hired last summer a full-time constitutional researcher whose job it is to research the issues coming out of Washington on the basis of original intent and prepare reports to the governor, to the legislature, and to the Attorney General's office, which we will then review and then share with other states as we're trying to build coalitions now. And what's, I think, phenomenal about this case, besides the fact that we need to win it, is we've actually now set up a template of how we can actually unite states together, resources of states, the abilities of different lawyers in different states, and the political pressure we can bring to bear on the federal government with a joining of forces by multiple states under, I'm going to be calling it the Obamacare model, to really push back against government encroachments on states' liberties and individual liberties. And I just think it's a phenomenal template now that we can use to kind of move forward and protect the original intent of the Founding Fathers. The whole concept of limited government and federalism, which really maintains individual liberties, has got to be defended by the states. And who defends it? Well, in the states, it's the Attorney General's office, primarily through the access to the courts, as we're finding now through where we are with this case. And I just think it was an amazing breakthrough for all of us, I think nationwide, all of us attorneys general and staff who've worked on this case. And it's something that we're going to bottle and we're going to utilize as we face other important fights down the road.
I know this is Mark again. I know we're kind of getting close to running out of time and want to make sure we hear from everybody. But y'all might enjoy this other little give and take, again, as to show how well prepared our counsel was, Paul Clement. And by the way, he did more than any others participating, and even though he's argued 50 times and has this amazing kind of ease, just like another day at the office when he's before the Supreme Court, but he prepared well in 6 moot courts, 2 with the Republican Attorney General Association to make sure he was prepared. But it's interesting, Breyer, who's kind of known as one of the brighter, more intellectual, more studious, great mind, great memory, knows the cases, was schooled again today by Paul Clement. And that, remember, John, when he mentioned McCullough, the great John Marshall opinion about federal banks, one of the most important decisions in history, and Breyer claimed that it was a Commerce Clause case. Paul Clement jumped right in and said, no, with all due respect, Your Honor, it is not a Commerce Clause case. The banks, the federal bank was created, but Congress did not order anyone to put their money into that bank, right. Which is what, if you follow the logic of the Affordable Care Act, Obamacare, is what they're asking to do now. And so he was able to quickly distinguish that case and actually educate Justice Breyer. And Justice Breyer didn't fire back. He didn't argue. He kind of looked like, oh, oops. How are we doing on questions?
We still have plenty to go.
Good.
We are starting to run out of time though, so we'll probably have time for maybe one or two questions left. Hopefully we can squeeze in two. Do want to remind everybody that we will have the recording of this call up on the website for John. It's at www.johnswallow.com. We will be taking a call now from Gene in West Valley. Gene's got a question in regards to paying penalties. Gene, go ahead and ask your question.
Yes, thank you for listening to me. I'm just wondering if they put a penalty on people for not having insurance, how do they think they're going to get the money from these people that can't afford insurance? It's kind of contradictory. And then another thing, if like when they talk about health or Medicare and for elderly people on Social Security,
right?
If they cut back on that, they're going to have a lot of people that are on welfare. And to me, it seems like we're going back into communism. They're telling us what we can and can't do, and I'm going to fight. I don't want nobody to tell me what I can and can't do.
Well, Gene, thanks for your question. And you're absolutely right. This whole concept of government taking care of everything is not very Republican to me. It's very alarming how closely aligned with principles of socialism it's becoming. But the way that this will work is the mandate is part of the Health Care Act, but also there's a part that requires the states to expand their Medicaid program. As you know, Medicaid is designed. It's a state program. It's the majority of it's funded by federal dollars, but it's designed to provide insurance to those who can't afford it. So they have certain thresholds. And one of the things this law does is it expands the eligibility so that people who make a little more than some of the others before actually qualify for it where they wouldn't have qualified earlier. And one of the things we're challenging is that this expansion is going to cost Utah taxpayers eventually hundreds of millions of dollars because it will require that much more state funding in addition to the federal fundings that are coming. So those who don't have the ability to buy insurance, the logic is, at least, it won't work this way, but that's the logic, that they will be able to enroll in state Medicaid and get insurance that way, and thereby avoid a penalty under the mandate penalty. But you are right. What's happening is this is probably a step program. We already know that this law is unworkable. Many of the companies are subject to a lot of the restrictions and like the minimum insurance provisions that they can't provide for their employees are getting waivers and exemptions from Health and Human Services right now. We already know that this law is not going to be workable, and it's probably just a step in the direction that the administration wants to go to a one-payer system or a national health care system. And so, your comments about socialism are very well grounded and founded, and that is one of the reasons we are working so hard as states to make sure that we challenge this law, that we did our very best work, that we had good leadership in the case, good strategies in the case, great counsel in the case, which we actually changed halfway through, and because we felt like we were not well enough represented earlier on, and we ended up getting Paul Clement, who is one of the brightest, like Mark said, one of the brightest legal minds in America and one of the most experienced advocates before the Supreme Court in the world. Mark, I don't know what you think, but I don't think we could have been better represented today. He was brilliant, and we're so fortunate to have Paul Clement. But that's the strategy. That's the effort and energy we put into this case of states, and we feel very good about where we are for that reason. We want to defend freedom. We want to defend liberty, and we want to stop the slide to socialism that we're on right now in this country.
And that's true, and I'm not taking anything away from Paul Clement. You're totally right, John, but I will remind people humbly, but truthfully, that Paul Clement wasn't anywhere on the scene when we, attorneys general, with our great staff, including John Swallow, drafted this complaint to begin with, and brought these very issues up. And yeah, we're very pleased. I mean, every one of us would like to argue, but we're pleased that we have the best and most experience to do it. But these were our arguments. I remember early on, I did a number of, when we first filed the lawsuit 2 years ago, a number of national interviews, and there were so-called brilliant constitutional experts saying that that we had no claim, this was frivolous, and mocked us and made fun of the attorneys general.
It was political.
Yeah, and it was political, but questioning. In fact, I remember one national talking person say, well, President Obama is a constitutional law professor, or was. He wouldn't do something unconstitutional. And I simply reminded that person that we attorneys general are constitutional practitioners. It's what we do for a living. And our job is to step up and protect under the 10th Amendment the states and individual rights. And that was recognized today by one of the justices, reminding them that these states filing this lawsuit are protecting individual rights like yours, Gene, that you just mentioned. And I'm very proud of that.
Hey, Mark, before we go any further, and we may have one more question, I don't know, but can I just throw the question came a few questions ago about the Cash for Clunkers program. And I answered that question in terms of the comparison between those types of programs and this bill, which kind of gets people into the marketplace unlawfully, unconstitutionally. But I want to make sure that everyone on the call understands that I'm not in favor of those types of programs either. But the difference between some of those types of programs and what we're talking about in this case is a constitutional issue versus a policy issue. I do not like the Health Care Act, Obamacare, for two reasons. One, I don't agree that it's constitutional. In fact, I'm sure it's not constitutional, and that's why we're fighting so hard. Mark feels the same way, and the other states do as well. But secondly, on policy, we all feel that it's the wrong policy as well, that it gets us closer to a socialist type one-payer system, a national healthcare system, and not closer, on the other hand, to the free markets where if you have businesses involved, where you have free market principles of economies involved, where you have portability of insurance, where you have supply and demand driving solutions, you have a more efficient solution to a problem that we have in healthcare in America. And so there's a constitutional side of these things, and then there's a policy side of these things. Policy is generally left to the legislatures and the people as they influence their legislatures. And so in that answer, I wanted you to know that I'm very concerned with addressing the constitutional side of that question rather than the policy side. But frankly, if there's not a constitutional question and there's a policy question, I don't like it anyway, and I'll argue against it, but I may not have the legal basis to fight against it. And I just wanted to clarify that, because I think it's an important question. People need to understand that as attorneys general, we deal with the constitutional and the legal. We don't necessarily deal with the policy side, but the policy side is still very important. And as a conservative lawmaker from 1997 to 2002, I was very into the policy side and concerned with the policy issues. Right now, as a candidate for Attorney General or as the Chief Deputy Attorney General, I'm very focused on the constitutional side of things and on the legal side of things.
Thank you, John, and thank you, Mark. It's been great to hear from our Attorney General, Mark Shurtleff, and our Chief Deputy Attorney General, John Swallow, after lively hearings today in the Supreme Court in Washington, D.C. Thank you all for attending this telephone town hall. Very grateful that you've taken the time. We've had some great questions today. Want you all to know that are sitting in the question queue. You can leave a message at the end of this, and we will get back to you as quickly as possible. Again, this will be recorded and placed up on the website at johnswallow.com. And again, thank you very much for your attendance.
Do you mind if I just make a quick statement just for a second?
Absolutely. We've just got a quick minute, though.
Dan, everybody, thanks for joining us today. The fight that we're fighting truly is monumental and historic, and we are truly fighting for the freedoms that we all hold dear as Americans. And we have a responsibility as states and individuals to stand up for those rights, because if we don't, we will be rolled by those who misunderstand the limits of federal power. And I just want to thank every single one of you for calling in tonight, for caring enough about your country and about your freedoms and what we're doing to take an hour of your time and listen in and ask your questions and be involved. Thank you very much. We appreciate you very much, and we will fight for you always. We'll fight for the liberties that we hold dear, and we feel like that's the job of the Attorney General, is to stand on the wall and push back against federal encroachment. So thank you very, very much. And Mark, thank you for joining us. It's always a pleasure to have you with us, and it's a pleasure working with you as well. You're a great Attorney General.
It was a delight. Thanks, John. Thank you all.
Thank you again for attending. Again, johnswallow.com. I hope you all have a fantastic evening, and please stay in touch.